but it's possible this term it could reach the Supreme Court as either a free exercise of religion or a free speech kind of case.
Okay. Well, thank you very much for that roundup of cases. And also,
Mary, thank you so much for having us and including us, and thank you especially for organizing this on such a significant day.
It's a testament of what a hardworking professor you are. You're now off to teach class, so have a good class.
I am. Thank you.
And now our cameras will turn back to the Delaware campus, and we'll talk with some faculty here, beginning with Professor Jim May, who is sitting next to me. Professor May has a book coming out later this year about global environmental constitutionalism, but today he's got his eye on a case that involves social media with interesting free speech implications. And the case title is Aloneness versus United States. So Professor May, you want to take it away and tell us about that case?
Yes, thank you, Mary, and good morning, everyone, and happy Constitution Day. The case that I'm going to talk about is about Facebook and the First Amendment. It's called Aloneness versus the United States. And in this case, the Supreme Court has to consider whether and the extent to which intent and perception matter in making threats online. I will cover background, legal issues, some implications, and what happens next. Now, at bottom, the case concerns the important First Amendment question as to whether it's the subjective intent of the speaker that matters, or whether what matters is the objective perception of the person who receives a message. Starting with first principles, the First Amendment says that Congress shall not abridge the freedom of speech, but it hardly plays out the way it reads. The First Amendment does not protect all speech. There are exceptions for libel, incitement to violence, obscenity, and fighting words, and one for something known as true threats, which is the issue in Mr. Aloneness' case. Let me tell you about him. Anthony Aloneness was a 26-year-old who lived with his wife and two small children in Allentown, Pennsylvania, and worked at nearby Dorney Amusement and Water Park. He had a single Facebook page under the pseudonym Dom DeRap of Tone Doogie. Tone Doogie had few Facebook friends. Anthony's wife, Tara, filed for divorce in 2010, and subsequently Anthony fell into a deep and dark state of despair. He then lost his job. He then began posting a series of disturbing messages on his Facebook page. First, these were about his former employer, and then he moved on to his wife, police officers, a federal agent, and a nearby kindergarten. His language was laced with brutally violent images. He suggested that for Halloween, his son dress in a costume that included his estranged wife's, quote, head on a stick. He talked about, quote, making a name for himself with a school shooting. His wife testified that she felt like she was being stalked. She was extremely afraid for her family and for her children, she testified. She took what he wrote as a true threat. So Anthony was convicted of violating a federal law in making this post. A federal law at 18 U.S.C. section 1875C, which makes it a crime to transmit in interstate commerce, quote, any communication containing any threat to injure the person of another. At trial, the district court rejected his request for a subjective intent standard. Anthony was convicted and sentenced to nearly 4 years of imprisonment. He challenged his conviction as unconstitutional, alleging that what he wrote didn't constitute a true threat under a case called Virginia versus Black. He claims that his subjective intent is what matters most. He said that he was just an aspiring rapper and that he was riffing in the style of Marshall Mathers, known as Eminem, who early in his career in particular often coined lyrics about committing violent acts, including murder, including against his wife. Anthony says that he was also mimicking the style of other rappers who have lyrics that are far more lurid and violent. He claims he didn't actually threaten anyone, that he posted only on his Facebook page under a pseudonym, didn't post these messages anywhere else or provide links to them. For example, that there was no evidence that his son ever saw the postings. Moreover, he notes that several of the posts included express invocations of the First Amendment and the true threat doctrine, and disclaimers and other indications that he didn't mean anything by a true threat. Which brings us back to Virginia versus Black.